I was basically asked by the organizers of this webinar to share with you some information and also some practical examples on 3 topics. And basically, sure, we will be all talking about prohibition of discrimination, but on the other hand, we have 3 main issues to concentrate. It will be the national institutions to combat racism, xenophobia, homophobia, and transphobia, which is so-called national equality bodies or national anti-discrimination bodies, or whatever they are called in different jurisdictions. We will also speak about the role of ECRI in the entire process, which is the European Commission Against Racism and Intolerance. And we will also talk briefly about the European Court of Human Rights, ECHR, and I was also asked to talk about some case law. Well, we have already one case which is already mentioned in a number of textbooks and brochures issued on this topic, and it's the case related to Georgia with more or less recent judgment delivered by the court. So we will also have a discussion on that. Well, when we talk about national institutions and when we talk also about the role, and also we have to discuss ECRI, it's very much interrelated, because European Commission Against Racism and Intolerance is the Council of Europe body, I would say very important body of the Council of Europe, which actually, I have to say, that was established in 1993, but it became operational after a year in 1994. And it's very important body which was formed actually to have a monitoring function, which specializes in questions related to fight against racism, discrimination on the grounds of race, ethnic, national origin, citizenship, color, religion, language, and also very recently mandate of the ECRI was extended, and it also covers now as grounds for discrimination, sexual orientation, and gender identity. And sure, it no doubt deals with xenophobia and anti-Semitism. In general, sure, it has a very broad mandate. And the strength of ECRI is that it's also authorized to visit all the member states of the Council of Europe. I guess among our participants, it's only Belarus, which is not covered by the mandate of ECRI, and ECRI has never visited Belarus. I hope one day time will come when Belarus will join Council of Europe and also be covered not only by ECRI, but also by the European Court of Human Rights and by other important mechanisms for the protection and promotion of human rights. However, I will still tell you briefly that, ECRI is quite an interesting and unique mechanism, and ECRI has members from all 47 members, which is appointment made by the Committee of Ministers of the Council of Europe. And actually, the main strength of ECRI is that ECRI has the mandate, as I mentioned, to visit the countries, members of the Council of Europe, and ECRI is entitled to check on the spot what is in reality the situation when it comes to the protection of rights related to the prohibition of discrimination. So, as I mentioned a couple of years ago, ECRI expanded its mandate, and actually LGBT issues, the rights of sexual minorities and discrimination on the grounds of sexual orientation were added to the ECRI mandate. And also now, if you open the recent reports of ECRI from the country monitoring cycle, you will find out that all reports basically contain the chapter which relates to this matter. And I will talk to that a bit more. In country monitoring work, ECRI analyzes the situation quite closely in each of the member states and delivers specific recommendations. And each report of ECRI is sort of a guidance for the authorities, which provides them first the overview, what is the situation in their country related to the protection of the rights of groups concerned, and also it provides recommendations which should be implemented. I guess we can all agree that implementation of recommendations is one of the problematic areas, and sometimes it takes a while to implement all the recommendations. And sure, there are sometimes long-standing recommendations where states can be a bit stubborn to implement them in practice. ECRI is unique because it's quite flexible, I would say. It's sort of a non-statutory body. It's not convention-based, for example, like ECHR or like the European Committee for the Prevention of Torture or some other monitoring bodies. And ECRI is, I would say, quite broad in its mandate and in the understanding of the matter it covers. So I have personally participated in the ECRI visits, and also I quite well know how ECRI works. ECRI does work which is not only related to the visits to the countries. ECRI does a lot for the promotion. ECRI does a lot for the education, and sure, ECRI does a lot when it comes to setting general standards. So ECRI elaborates usually a set of standards which is called general policy recommendation, and which are the recommendations for all the member states of the Council of Europe. And usually, well, as a rule, general policy recommendations are addressed to the governments of the member states. However, if, for example, sometimes as a consultant, I have to do some work in the countries which are not members of the Council of Europe. Like recently, I had to do something in Turkmenistan, also in Uzbekistan. I would tell you that when we talk about standards, sure, for example, in Belarus, quite often, I worked there a couple of times on particular issues, and this issue was raised that, sorry, but Belarus is not member of the Council of Europe. However, when we talk there about UN standards, for example, which are universal, I usually refer to the European standards as well, including the practice of the ECHR, its case law, including ECRI standards. So if you really want to see detailed standards when it comes to the prohibition of discrimination and, well, to say it more precisely, fight against racism and intolerance in Europe, ECRI standards are one of the best developed, and those are the so-called general policy recommendations, and they provide a guidance how to draw national strategies and policies to be best compliant in Europe with European standards. ECRI so far has issued a number of specific general policy recommendations, which might be, for example, very much interesting for particular state bodies. Well, the first GPR was issued in 1996, and it's on combating racism, xenophobia, anti-Semitism, and intolerance. And second general policy recommendation was issued in 1997, but revised in 2017. And I had the honor to be member of the working group composed of few members of ECRI working on the revision of the general policy recommendation related to the equality bodies to combat racism and intolerance at national level. So here, those bodies are meant about which we will be talking in a due course. Well, then the ECRI has general policy recommendation against intolerance against Roma and Gypsies, and you know that it's very important topic, also problematic, and sure, I mean, it's not surprising that ECRI had to draw special attention on the issue. Well, we also have ECRI general recommendation on national surveys on the experience and perception of discrimination and racism. We also have general policy recommendation on intolerance and discrimination against Muslims. We have also GPR on dissemination of racist, xenophobic, and anti-Semitic material via internet. And also there are general policy recommendations on national legislation to combat racism, also very important, having a lot of intersections with the national specialized bodies. Also combating racism when fighting with terrorism, fight against anti-Semitism, discrimination in schooling and school education, in policing, very important recommendation for the police forces of all countries in Europe when it comes to the issues related to the combating racism and racial discrimination inside police. And we will talk about the importance of the police force later, also in the context of the case we're going to discuss. Also we have recommendation in the combating discrimination in the field of sport, employment, against Roma, migrants. So why I listed those all recommendations? You see the topics which are somehow indicative of the challenges we have all over the world, and especially now in Europe, when it comes to the areas where the work of the anti-discrimination bodies is very crucial. And here you see the topics: it's migrants, hate speech, employment, Roma, gypsies, police, etc. I guess you also noted, all of you, the recent developments in the United States, and the word racism was mentioned a number of times, and US police was also in the center of all those events. And you remember how all started when the black man was killed by the policeman while he was arresting him. And then you know that now it's still not over, and there are lots of discussions how to reform the police, and that racism has been a problem within US police force since number of years, and somehow it has to be tackled. And however, we're not going to talk much about US today, but we will talk also in the context of Europe. And when ECRI has issued general policy recommendation on policing, it has a number of interesting things to understand why it's so important that police is free of racism, and police is the main mechanism actually to fight against racism. So, ECRI, as I mentioned, it has the mandate to visit the country, and usually ECRI comes up with the list of the countries to be visited. If I remember correctly, now ECRI is in the 6th monitoring cycle, and usually during the year it somehow visits 10 countries per year, and then issues the report, which at some point gets published after a while. First, ECRI holds dialogue with the country concerned, and usually then the publication occurs. So you can find all ECRI reports on the ECRI webpage. And sure, I mean, you will see the reports on Ukraine, you will see the reports on Georgia, on Azerbaijan, Armenia, Moldova, but not on Belarus yet. And it's quite interesting to see what are the main issues ECRI is covering. Well, I have to tell you that ECRI deals with everything, starting from legislation, also with the practice, and also ECRI dedicates a lot of time to recommending states how they should shape their criminal, civil, and administrative laws in order to protect people from being discriminated on any of the grounds. And also, sure, ECRI provides advice to national human rights bodies. It also recommends the national authorities how those bodies should be formed and how they should work. ECRI provides recommendations for integration policies, and ECRI deals with most of the issues which can be considered by the committee, by the commission. And as I told you, recently ECRI started dealing also with the issues of the sexual minorities, of LGBT communities. And in all reports now recently published, you will find provisions which talks about problems of homophobia, transphobia, and all the related matters. I know quite well, for example, the last report on Georgia, and I think ECRI will be visiting country soon again. And I know quite well that not all recommendations have been implemented so far, but many of them have been addressed in the course of the year. National bodies, and I was kindly asked by Mara to talk about them. Well, I have to tell you that national specialized bodies play a very important role when it comes to fight against discrimination. And I have to say that these bodies come in different colors. I mean, they are not all similar, and many countries have different models, and it's all around the world. So usually national authorities decide what type of bodies they have to come up with. But nowadays, I have to tell you, it's quite practiced in most of the countries that usually ombuds institutions, national human rights institutions, take over the mandate of anti-discrimination body. But it also happens that you have a separate institution. It's more, I would say, Western European model. However, if you check how this mechanism operates in Moldova, you will also find out that in Moldova, for example, you have a separate Equality Council with anti-discrimination mandate, and you also have typical ombuds institution, which also has a mandate against discrimination. Well, I have to tell you that in Georgia, for example, we have a specialized body which is embedded in the ombuds institution. When I was the ombudsman, it was not yet the case because there was no separate law against discrimination. However, ombudsman that time also was fulfilling the mandate of the national anti-discrimination body. So when ECRI was visiting Georgia, ECRI would come and meet ombudsman and discuss with him how he implements mandate in that direction. And usually in the report, then you would read a lot of nice things about the public defender and his work. It's not only about me, also about my predecessors and successors. However, ECRI usually had sure recommendations that there should be a separate anti-discrimination body with a strong, distinguished mandate. Well, when working on GPR number 2 and deciding what should we tell all 47 member states, how this body should look like, I mean, what should be their mandate, institutional architecture, that's a very nice term, also how they should work, and how far they can go, we're arguing in the group a lot. To be honest, I mean, I do understand that many countries quite often have no other option other than use the existing body, like the Ombuds institution. But nowadays, we see what is happening all around Council of Europe, and not only in this region. We get Ombuds institutions being provided additional mandates, yeah? In many countries now, Ombudsman fulfills the role of the national preventive mechanism under the optional protocol to the Convention Against Torture. In many countries now, Ombudsman is the national equality body, anti-discrimination body. In many countries, Ombudsman also has the role in the monitoring of the implementation of the UN Convention on the Rights of People with Disabilities. And sure, it has its core mandate, which is general human rights mandate in the country. In some countries, it's rather limited. In some countries, it's broad. For example, if we take Ombudsman of Azerbaijan, a human rights defender of Armenia, we talk about public defender of Georgia, we'll look also at the Ombudsman of Moldova, Human Rights Commissioner of Ukraine. You will see lots of similarities in the mandates of all those bodies, but if I'm not mistaken, Moldova is the only exception which has separate anti-discrimination body. I think there is also some overlapping in the mandate. However, still, I mean, those two bodies operate under different laws, and I think many things on the success of the both bodies depend how well coordinated they are, how well they share the information, and how well they both work, I mean, on combating discrimination in the respective jurisdiction. But again, I mean, if you look into ECRI general policy recommendation number 2, which, as I mentioned, is solely related to fight against discrimination and setting of the specialized bodies, you will find out that ECRI provides lots of discretion to the countries which are in the process of setting those mechanisms. Actually, when we talk about the equality bodies at the national level, ECRI has provided a very detailed set of standards, and I call it minimum requirements. So actually, well, it goes without saying that there should be a constitutional provision or legislation passed by the national legislature. In this case, in most of the countries, it's parliament. And, well, countries, as the GPR says, can establish one or more bodies, equality bodies. However, when you have more than one body, it's very important that there is not much overlapping and resources are allocated adequately so that they all have a clear mandate and they cooperate, but on the other hand, not all of them is doing the same job. Well, and they should be independent. I guess all of you is aware of so-called Paris principles. Yeah. Well, Paris is nice as a city, and also principles are quite good. They are actually standards for the national human rights institutions, and there is a lot about independence. And when national human rights institutions are accredited or re-accredited, for example, by the special body on a global level, sure, everybody looks into whether they are really independent or not. So equality bodies also should be independent, both de jure and de facto. It means that they should be separate legal entities. They should have clear legal foundation. They should have their own budget. They should be able to recruit their own staff. They should be able to exercise their duties without interference by executive or legislative branch, so on and so forth. So I don't think I need to go into very much detail. However, when it comes to mandate, institutional architecture, functions, competencies, appointment, dismissal, safeguards in terms of office and leadership, sure, it should be all listed in the law and should be quite clear. So it means that these bodies, when we talk about national equality bodies, more or less should comply with the Paris principles and their requirements. And when they are inside the Ombuds office, it, however, means that if its Ombuds office is fine and it's considered as an independent body, then equality body embedded in the Ombuds office should be also considered as being independent. But again, to be honest, I have a bit mixed feelings. What is better, having this equality body within the Ombuds mandate or have a separate one? I would say that if you have a proper separate body with proper funding, proper mandate, proper legislation, it can even work better. However, if there is a strong ombuds institution with proper resources, it can also work quite well. The only risk quite often is that the mandate, the equality mandate, might be sometimes lost in between other mandates. As I mentioned, Ombudsman can be anti-torture body, body to protect people with disabilities. Above all, it has this general human rights mandate dealing with everything. And then it has also this anti-discrimination mandate. And ECRI says that this mandate should be very explicit and it should have its own space within the ombuds institution, which is not always easy. Many ombudsmen, for example, establish Department of Equality and Non-Discrimination, or they call it Center for Equality or Against Discrimination. However, I mean, it's also, I would say, a right thing to do when you have a deputy ombudsman, for example, being in charge of this direction. Like, for example, also when, for example, you have few areas, which should be distinguished, prohibition of torture, rights of a child, prohibition of discrimination. Quite often it becomes very difficult because you have this big body with its staff, and then you have to have this separate segments. Also, ECRI says that you should have a separate budget line. And then you come to Ombudsman and you ask, how much are you spending on equality issues? And then you have a general budget with a big figure, and it's sometimes very difficult to say how much is solely spent on this activity. But again, some problems arise when actually you deal with some issues which classically are not usually under the mandate of the ombuds institutions. And there might be some problems with that, and I'll talk about it briefly. For example, ECRI also said that, well, the body in charge of equality and prohibition of discrimination should have also the mandate to litigate, so to provide legal assistance to the victims, as also mandate to protect them. Well, it's not that easy, I have to say. And it says that if it's done like when you have this multi-mandate body, like ombuds institution, then those things should be handled by the different entities within the ombudsman office. So you get something quite unusual, I have to say, and not all ombudsmen are successful in arranging it the way it's needed. I'm not going to give you any particular examples, but I have to tell you that it can be quite a headache to comply with all those recommendations. And I remember that in Strasbourg, back in 2017, when ECRI invited all national bodies, some of them were very unhappy with this recommendation, with this general policy recommendation, saying that, okay, they can't comply with all the requirements, however, they still are fine and they do their work. And I think those were a few equality bodies from Nordic countries, more specifically, I think Sweden, there was also maybe Finland, I don't remember, a couple of others who said that, well, maybe they don't fulfill all these recommendations, however, they are still there and they do their job. Well, I can also tell you that you might have a proper legal foundation, you might have money, but sometimes you still might be unable to do the work the way you are supposed to do. So when it comes to institutional architecture, as I told you, there are two options. You might have equality body forming a part of a multi-mandate institution, like in Georgia, like in Ukraine, like in Azerbaijan, like in Armenia. But also there might be that there is a separate body. I can't call it a parallel body. It's a separate body which has powers and mandate related to fight against discrimination and promoting equality. However, it works hand in hand with the local ombuds institution. So I think that in Belarus, for example, there is neither ombuds institution nor distinguished equality body. However, in the future, I mean, when the time comes to form those bodies, I think there will be the possibility also to find out what is the best model. And there are some examples. So I know that there have been a lot of assessments done about the weaknesses of each model and about the strengths. For example, I know that, for example, my colleagues in Moldova do a great job. However, they are always trying to make things better, to have more resources, trying to do more work, but then also to work hand in hand with ombudsmen on those issues. But sure, there are some hurdles, some problems which have to be addressed from time to time. And well, if you stay happy with what you do, you will never develop. So it's usually good to be self-critical on some issues. In Georgia, for example, where the anti-discrimination legislation is relatively new, and for the ombudsman, I can't say it's a new mandate, but the way it's done now, it's really considered to be a step forward, because now ombudsman has a very broad anti-discrimination mandate. It deals not only with public entities, but also with the private ones. Recently in Parliament, we passed the law where ombudsman is also the body in charge of prohibiting sexual harassment, and it has a very broad mandate now. It has a separate department with number of staff, but sure, I mean, when you look into the legislation, and also let's not forget about the courts, because they play the crucial role. Ombudsman might do its job perfectly, but then when the case ends up in the court, for example, in Georgian reality, if case is handled by the court, then ombudsman has to stop looking into the case, because that's the requirement of the law. And also, well, court can adopt a decision which should be enforced. Ombudsman has soft powers, so to say. Ombudsman can recommend, ombudsman can instruct the state bodies on a particular issue, both systemic and individual cases, but ombudsman is not the body who can issue a fine, who can provide just satisfaction and also issue the sanctions. In Georgia, for example, when there was a discussion, one has to note that there was the initial draft law proposed, and it was introducing the post of the equality inspector. So it was a separate body, not related to the current ombuds institution, and I would say with quite a strong mandate, including the authority to issue sanctions. I mean, for example, financial sanctions, fines, and also other possibilities. And then you could go and argue in the court if you disagreed with the ombuds decision. However, later the legislator decided that, why creating a separate body when we have strong ombuds institutions? Let's bring this function also into the ombuds institution. But now you see that also the weaknesses, that enforcement functions and also sanctioning is not there, because ombudsman is not supposed to do such things. If you need that, you go to the court. So statute of limitations is also quite strict. If I remember, if it has not changed, it's 3 months to address the court. So quite often it happens that people decide to go directly to the court than to the ombudsman, because they don't manage with both. And again, as I said, it's incompatible. It's something dealt by the court, then ombudsman cannot deal with the case. Ombudsman can also, as a third party, go to the court. But again, all those things are quite complicated. And again, much depends on also how well prepared are the judges and the judiciary. Colleagues of mine have published a nice research back in 2016, if I'm not mistaken, and they somehow proved that there are lots of deficiencies at the level of judiciary, issues related to the admissibility, decision-making, also burden of proof when it comes to the litigation, so on, so forth. Also, I'm not sure that we have too many good lawyers who are able to take the discrimination cases to the court. It's also another area where the lawyers have to be trained a lot. When it comes to other issues, I was asked also to talk with you about the ECHR. Well, we all know that European Court plays I would say, the most important role when it comes to protection of human rights. And I think the Council of Europe member states and all of us are very lucky to be covered by the jurisdiction of the court, because, well, court can really resolve some serious issues. It's both related to the individual human rights violations when it comes to restoration of the violated rights, although it takes quite long. Well, because once I remember reading that court is the victim of its own success, because when the body is good, it has lots of clients. So that happened with the court as well. I mean, it was flooded with the cases, despite number of reforms and changes the court has adopted in the course of the years. I mean, well, it still has issues when it comes to the backlog. And sometimes when colleagues are approaching me, some of friends of mine who wanted to complain, and I'm telling them, well, but be aware, you will have to wait at least 2, but maybe even 5 or 6 years until the court delivers the judgment. They are looking at me, they say, you should be joking. No, I'm not joking. That's the issue. Well, I can't say that the anti-discrimination mandate of the court, I mean, is the best. No, I think it's much weaker than on some other rights when it comes, for example, to right to fair trial, personal liberty and security, right to life, prohibition of torture, or even when it comes to Article 10, 11, 8 of the Convention. However, I mean, you know that, Article 14, which has no separate standing, it should be usually invoked in conjunction in main provisions of the Convention, but we also have Protocol 12, Article 1. I think that, if I'm not mistaken, it has not been ratified more than by the half of the Council of Europe member states. So I think it's 20 or 21 ratifications so far. So you can only bring claims under Protocol 12 against 21 states which have acceded to this protocol. Well, I don't have time to discuss with you all the case law of the court, either under Article 14 or under Protocol 12, Article 1. However, I want to bring to your attention one case, which is against Georgia, and it's very much to the topic. So it's case of Identoba and others versus Georgia, and the judgment which was delivered by the court in 2015. So it's, well, when it comes to how the court works, it's quite recent. And actually, it's a quite interesting case, and I think it should be interesting also for our colleagues from all other countries attending today this webinar. Well, the case originated in an application against Georgia. It was lodged by non-governmental organization Identoba and also by 14 Georgian nationals. And actually, the case, was related that these people and actually representatives of the organization were subjected to violence perpetrated against them by the private individuals, and the lack of police protection during the peaceful demonstration of 17th of May. It happened in 2012, and you know, 17th of May is International Day against homophobia and transphobia. So actually, complainants allege that, actually their peaceful demonstration, which ended up in a clash with counter demonstrants, I would say these were some, let's call it far-right groups, actually quite homophobic and aggressive. And the issue was that, sure, the rally could not continue because, if I remember correctly, from the concert hall in the center of Tbilisi, who has been in Tbilisi, you know, this is a round building in very center of Tbilisi, they wanted to have a short, I would say, demonstration. They were marching down to the downtown in direction of the parliament, and that happened that actually 1 week in advance, they filed a notification to the municipality, telling the municipality that on 17th of May at around 1 p.m., members of the LGBT community will be holding a rally. And well, under Georgian legislation, you don't need a permission to hold a rally, but if you are planning to block the traffic, however, you have the obligation to notify the municipality. So everything was done in accordance with the law. They filed this notification. Municipality took a note. As I remember, they also called the police and they had communication with some high-ranking official telling him that they will be holding a rally and they need also certain attention from the police, certain protection, so that the rally is peaceful and it's not interrupted. However, well, it was also quite known that there were a few aggressive groups which were preparing somehow to prevent this rally from taking place, and they were quite, I would say, they were they were already doing some preventive activities in that regard. They were very active in social media, saying that they would never allow this to take place in the center of Tbilisi. And actually, this was two groups. It's Orthodox, it's a union of Orthodox parents of Georgia and Saint King Vakhtang Gorgasali Brotherhood. So you already see that these organizations, even the way it sounds, yeah, they should not be very much minority loving. So actually what happened that they also organized the rally. They somehow stopped the demonstration of the LGBT community. They were holding some kind of posters, banners, and the part of them was destroyed. I think they also physically assaulted a couple of people representing the LGBT organizations and community. One of them was beaten on the spot. Police was nearby. However, the policeman present said that they were not the part of the police which has to deal with this. And after a while, only patrol police officers arrived. They were, well, okay, the amount of policemen was not that big. They were few. They tried somehow to diffuse the tension. However, as I remember, the main problem was that they detained only people who were representing the LGBT community. Some of them were forced into the patrol police car and taken away. They were then released after a while from the local police department. However, they were taken away, and police claimed that they came there somehow to avoid conflict and the clashes. And well, this other part, I mean, this Orthodox Parents Union and this Vakhtang Gorgasali, whatever organization, never left the place. They didn't allow the rally to proceed. They were insulting people and they were using some, I would say, unacceptable language, calling them faggots, whatever. And they were also issuing lots of threats in direction of the participants of the rally. And they were threatening them. Also, well, as I told you, a few of them were physically assaulted. Okay, after that, sure, the rally was stopped, I mean, and then representatives of the LGBT NGO Identova and also private individuals complained to the police and the prosecutor's office. Well, investigation was proved to be ineffective because first the authorities didn't want to investigate anything. However, later they had to launch investigation, but not the way required. You might know that Georgian legislation is quite okay when it comes to anti-discrimination clauses, including the criminal code, and committing a crime on those grounds is considered to be biased motive and aggravating circumstance. I mean, committing a crime on homophobic motives is an aggravating circumstance in the terms of Georgian criminal code. But again, investigation never started with these provisions of the criminal code. And then after exhaustion of domestic remedies, Identova and few private individuals complained to the European Court of Human Rights. It took quite some time to get the judgment. However, the court found violation of number of articles because it considered first that state failed to protect the participants of the peaceful demonstration, and court established that there was violation of Article 3, which is prohibition of torture and inhuman, degrading treatment and punishment, in conjunction with Article 14, which is the prohibition of discrimination in the enjoyments of the rights set forth by this convention. And then the court also established that actually there was a violation of Article 10 and 11 in conjunction with Article 14. of the it was violation of Article 11 in conjunction of Article 14 of the Convention, and then also it awarded just satisfaction to the complainants. I think each of them received 3,000 euros and one of them 4,000 euros of the compensation as provided by in accordance with Article 44 of the Convention of Human Rights, European Convention of Human Rights. So actually, I have to tell you that despite some minor details where the court considered that there was no need to examine these complaints under the all claimed articles, which was 3, 10, 11, 8, and 14, the court found violation of mostly all provisions. And actually, the court said that state failed to protect their rights. They were subjected to the treatment contrary to the requirements of Article 3 of the Convention, and they were subjected actually to inhuman treatment. And also the court claimed that the right to peaceful assembly and association was also breached. And sure, I mean, the case was there was a breach of Article 14 of the Convention, which is prohibition of discrimination. So actually, well, the case was quite successful on the side of the complainants. However, I mean, it once again demonstrated that authorities failed to protect the rights of the minority group, although they were warned in advance. And they should not have been taken by surprise. They failed to investigate the cases, and also it's the breach of Article 3 of the Convention when you are unable to conduct effective investigation, and also other rights were breached as well. So Identoba nowadays is part of number of textbooks, number of manuals where people are referring to this case because it's quite an interesting case, and I have to tell you that until in Georgia we have an issue where you have more policemen than the participants of the rally on 17th of May. I mean, representatives of the minority groups, and not only them, there are some people who are themselves not forming the group of sexual minorities. However, like a number of my friends and myself are quite supportive of these groups, they quite often see that they are they are unable to exceed the number of the policemen. I remember, well, what happened on the next 17th of May. Then what happened also 2 years ago, when actually the entire territory around the governmental building was blocked by the police and yellow buses where there were only a couple of dozen of people. And I think last year there was another case when representatives of the LGBT community had somehow to have a small march, small rally inside the outside the Interior Ministry building, because where they really wanted to hold this rally, it was more or less occupied by the far-right radical groups, claiming that they will never allow it to happen. So I think that the problems which we had in 2012 are very much still present in the reality of Georgia, and it will take a while somehow. But this case, Identoba and others versus Georgia, I would say it's a good guidance for the authorities here, what they have to do in order to ensure the rights of minorities properly.